Well, the Daybells may have a strategy in play as Lori Daybell, who incidentally instructed the judge to call her Mrs. Daybell, appeared in an Idaho courtroom to be arraigned on murder charges, the kind of charges that could end her life. Hello, everybody. Welcome to Profiling Evil. That's it. The grandparents and sister of three of the four people that Lori Daybell's accused of murdering watched from the gallery. Just hours earlier, her husband appeared in the same courtroom, and frankly, I think they've got a strategy in mind. Well, thanks for joining us for this special edition. As we get started, take a moment, if you would, hit that like and subscribe button. I want to send a special thank you to all of you who are channel members. Your contribution helps, and it's deeply appreciated. Now, let's get started with Chad Daybell's day in court. The day started with him sitting in the courtroom as prosecutors tried to convince the judge that it would be cheaper to bring jurors from Ada County over across the state to Fremont County, rather than the state having to move their entire team across the state to prosecute. I guess they think it's better to inconvenience the public jurors, people who are leaving their hourly wage jobs and their own families and being forced to travel across state and then forced to sit in a courtroom rather than having court officers come to them. The Daybells are charged with multiple crimes, including first-degree murder. Now, the charges swirl around the deaths of Lori's children, 7-year-old Joshua J.J. Vallow and 16-year-old Tylee Ryan. And let's not forget, charges also include Chad Daybell's first wife, Tammy Daybell, who died on October 19th. Their combined trial is scheduled to begin in January of 2023, and it's slated to last about 10 weeks. But now there are new twists and turns. Lori's case may change things, and I'll talk a little more about that in just a minute. But true to form, Chad sat in the courtroom, dressed in a white shirt and a blue tie. Throughout the proceeding, he remained motionless, said nothing. To argue their point of why the trial should be occurring in Fremont County, the prosecutor said the defendant picked the venue when the bodies were buried on his property, and he killed Tammy Daybell. That's a pretty powerful argument to have that in Fremont County, not somewhere else. Now, the judge denied Daybell's attorney, Mr. Pryor, who requests that they dismiss the hearing. The judge instead invited the state to put on their witnesses, which included a clerk who addressed the court and talked about the costs involved in lodging, feeding, and transporting a jury over to Fremont County, and the personnel that would be required for the trial. The state said it would be less expensive to bring the jury to them rather than take the team to Boise. And they actually made a really good point. The state contends it would cost about $231 per person per day to have people go over to Ada County. But here's what's really important to me. It would place a heavy burden on the sheriff's office, who would suffer this severe staffing shortage while they have all these people gone to testify and do other court business. The sheriff went on to say they would need nearly $216,000 to cover staff and security for this case. Well, true to form, Judge Boyce said, I'll take it all into advisement and I'll offer my findings at a later time. Now, he didn't use those specific words. I'm paraphrasing. But with that, we know that it's going to be a bit before the judge makes a ruling on whether that thing really is held in Ada County or in Fremont County. But with that, let's stop for a moment and switch gears and talk about Lori Daybell's arraignment, which occurred just shortly after Chad Daybell's hearing. And wow, I'll bet the judge didn't see the twists and turns that were going to come in that hearing. But before we go on, I want to just take a moment and invite you to pick up my book, Deceived, an investigative memoir of the Zion Society cult. It's important as we talk about Daybell's because it explores cult behaviors, why people join cults, and why seemingly intelligent people can be compelled to become criminals. I think you'd find it interesting. It also explores how cults recruit people, and it talks about the investigation into the Zion Society cult. You can get deceived at profilingevil.com. And I want to just tell you, if you purchase the book, the proceeds are going to build a new children's advocacy center. That's right, we're not taking the profits. We're trying to turn it over to help in building an advocacy center and in training police officers and students through the local university. Now, let's talk about Lori Daybell. Everybody got their first live glimpse of Lori, Noreen Cox Yanes Yangiola, Ryan Vallow Daybell as she appeared before a judge to hear formal charges read against her. This process is called an arraignment. And arraignments are court hearings that take place before a criminal judge or a magistrate. At an arraignment, defendants like Mrs. Daybell are presented with the charging documents. It's there that they have to enter a plea of guilty or not guilty. And in this case, it's there where a trial date is set. Listen in as Judge Stephen Boyce reads the charges to Lori Daybell.
Began with the filing of an indictment that was issued by a grand jury on May 25th, 2021. That indictment sets forth the criminal charges the state's filed against you. The indictment is not evidence, rather it lists the criminal charges that will be prosecuted by the state of Idaho. Mrs. Daybell, you're brought before this court to answer for the indictment that was filed in this case, which alleges that you have committed serious crimes in that 6 felony charges have been filed in the grand jury's indictment. Before I allow you to respond by entering a plea to the charges in the indictment, I'll ask you a few questions. First of all, did you have any questions about your right and plea options in this case? All right, and have you seen a copy of that indictment and had it provided to you? And have you had enough time to review that indictment with your attorneys?
Lori quietly answered that she understood each charge, and when the judge began to read each summary charge against her, he was interrupted by her defense attorney, Jim Archibald, who indicated that Lori would waive that reading.
3.
Your Honor.
Yes.
We waive the reading if a summary is acceptable.
Very well. Mr. Archibald, if you read that, I'm fine with that.
The judge then read the charges. And I want you, while we're watching this, to pay close attention to the Woodcocks, JJ's grandparents. Watch as they react when JJ's name is read in the murder charges.
Conspiracy to commit murder in the first degree of Tylee Ryan and to commit grand theft by deception. I'll advise you, Mrs. Daybell, that the possible penalties associated with those charges are the conspiracy to commit first-degree murder is punishable by death or imprisonment for life, and if the death penalty is not sought, a mandatory life sentence with a minimum period of confinement being 10 years. That's the possible penalty on the conspiracy to commit first-degree murder charge. You understand that charge and the possible penalty there? Yes. All right, the next count of the indictment alleges a charge of first-degree murder, and that is in relation to Tylee Ryan. That charge of first-degree murder carries, again, the penalty of being punishable by death or imprisonment for life, and if the death penalty is not sought, a mandatory life sentence with minimum period of confinement being 10 years. You understand the charge and the possible penalties in count 2 of the indictment? Yes. Okay. Count 3 is a charge of conspiracy to commit first-degree murder and grand theft by deception. That is an allegation relating to an alleged murder in the first degree of Joshua Jackson Vallow, hereinafter referred to as J.J. Vallow. Again, that conspiracy to commit first-degree murder, I've already indicated what the penalty is. It's the same as in the prior count. Do you have any questions about that charge or the possible penalty?
Well, under the United States Constitution, those people who are charged with crimes are considered innocent unless they either plead guilty or are found guilty in a court proceeding. Listen as the judge prepares to ask for a plea on each of the charges Lori Daybell faces.
At this time then, I'm going to go back through the charges and ask how you plead as to each charge. Before I take that plea then, do you have any questions for the court or anything you need to discuss with your attorneys?
Your Honor, she intends to remain silent. I'll ask the court to enter and not guilty pleas for her and set the matter for trial.
Very well, Mr. Archibald, then that is her right to remain silent. The court, upon entry of that, will enter a not guilty plea as it relates to all of the counts alleged in the indictment against the defendant.
Another guarantee under the U.S. Constitution is the right to have a speedy trial. Typically, arraignments have to occur within 72 hours of an arrest, but this arraignment was put on hold while mental health workers worked with Daybell to return her competency. She's now competent to stand trial, and the judge reminded Daybell that she has a right to a speedy trial and that she was currently scheduled to be tried at the same time as her husband, Chad. He's again being that case, that companion case is set to be tried in January of 2023. That's 9 months away, and it's clearly outside the scope of a speedy trial, something guaranteed under the Sixth Amendment, and something that the state of Idaho requires happens within 6 months of arrest if someone is wanting a speedy trial. Listen as the judge asks Lori if she's willing to wait that long for her trial.
Having entered those not guilty pleas then, Mr. Archibald, we'd like to discuss the setting of trial in this case. As I'm sure you're aware, there's a companion case that is already scheduled for a trial to start on January 9th. The court's made some previous rulings that apply to this case and were set in that case as well, indicating that these cases would be tried in a joint trial. In order to have your client appear for that trial date, that would require her to go outside of the time frame for speedy trial. Have you discussed with your client her speedy trial rights and whether she intends to waive those to have the trial as now set, or what's your plan on the trial setting?
Yes, Your Honor, we have discussed it. She does not intend to waive her right to a speedy trial.
All right, I'll note that the defendant's in custody. There is a statutory requirement under Idaho Code 193501, subsection 1, which does require that the matter be set for trial within 6 months if speedy trial is not waived. That would give a deadline of approximately October 19th for the trial.
And there you go. Lori Daybell's demanding her right to a speedy trial. I find this intriguing because just a few days ago, her attorney, Jim Archibald, argued that he wanted her trial moved to late 2023, more than 18 months away, stating that even he hasn't had time to start putting her death penalty defense together. I found it interesting because prior, Chad Daybell's attorney said that's not my problem, that he's not prepared. I want this thing to happen earlier. And the judge picked the January date. Well, now, knowing this speedy trial requirement has to be met, the judge announced that he could set the trial sometime before October 19th. October 19th, the day Tammy Daybell was reported deceased. How strange, how interesting is that? Lori Daybell's a co-defendant in Tammy Daybell's death. And that date didn't go unnoticed by Kay Woodcock, who picked up on it and made comments about it later on. In reality, that October 19th date's the last possible date that the trial could begin under this speedy trial rule. But we learned today that the actual trial date is scheduled for October 11th. And that is expected to again last about 2.5 months. That means that the findings will probably come after the first of the year. The state then reminded the court that Lori wanted a date for trial that was before that January 2023 date again for the companion case. And because of that, it would be necessary for the court to have another hearing that would include Chad Daybell's attorney to see if these cases should remain joined or if after all this they should be separated. Listen in on that discussion.
Your Honor, I think with the request to have the trial held within 180 days, it sounds like this court is going to look at the court's calendar. I think the state's thought process would be we'll look at our calendar as well. Right now, there is a court order indicating these matters will be tried together, and there had been a severance motion which was denied in the companion case at this point. But we will look at the state's calendar and request the opportunity to provide briefing to the court if the court would allow that with regard to whether or not a separate trial should be set.
Okay, we will take that under advisement. It's a decision that obviously needs to be set quickly, the trial setting with a limited time frame for us to make these arrangements for trial. And so I will contact counsel about calendaring, which we can do off the record, and confirm dates for the commencement of a trial. The presumption being at this time that it would be a single trial together with both this case and the companion case of State versus.
Well, as Lori Daybell left the courtroom, the Woodcocks headed out front to share their thoughts with the media. Here are two segments from their comments that I thought were really compelling. And if you'd like to see that whole press conference, go over to East Idaho News for the longer video.
We appreciate it. I was very saddened. I was very saddened to hear JJ's name. And I'm very happy at the stage that we are at right now. This case is moving forward. It's moving forward with respect. I personally introduced myself to both of the defense attorneys. As I always do, I tried to say hello to everybody and thank everybody. But I think we're very close to a combination of 3 hard years. And I want to thank everybody for all that y'all's continued support. It is very important.
Unnerving. I honestly thought I wouldn't feel anything, but I couldn't have been further wrong. I look at her and think, I love her and trust her. I trusted her with
Our baby.
a life
With our baby.
that we.
So let me remind you of the charges that Lori Daybell faces. First-degree murder in the death of Tylee Ryan. First-degree murder in the death of Joshua Vallow. First-degree murder in the death of Chad's former wife, Tammy Daybell. Conspiracy to commit first-degree murder and grand theft. Conspiracy to commit first-degree murder and grand theft. That's one for Tylee, one for Joshua. Conspiracy to commit first-degree murder in the death of Tammy Daybell. And grand theft related to Social Security survivor benefits. So what are your thoughts at this stage of the criminal case, folks? Do you think that Lori and Chad Daybell will be tried at the same time like we previously thought was going to happen? Or do you think one or the other might turn state's evidence in hopes of getting a better deal? Now, there were two behavioral things that I saw in this segment of cases that really intrigued me. In my opinion, there's still a real connection between Chad and Lori Daybell. I don't think that I necessarily thought that was going to be the case. And I say that with the caveat that I think it's at least in Lori's mind. I say this with a reminder that she advised the court that she wanted to be addressed as Mrs. Daybell, not Lori Noreen Vallow or Lori Noreen Daybell or any of those other names. She wanted to be called Mrs. Daybell. I find that significant, and I haven't quite worked out in my mind why that's so significant to me. But I think behaviorally it shows that something's going on. They've got something cooked up there. I also found myself wondering if she might really be getting her senses back. That the reality of this brutal homicide that she's accused of happening is really sinking in. I say this because she did something that I didn't expect. she pushed for a speedy trial. And I would guess that it comes against the wishes of her attorney. Just remember, he wanted more time to prepare. This is a death penalty case. Having less than 6 months seems completely out of whack to me. But then again, I wonder if Jim Archibald has been sending the court mixed messages, and rather than starting now like he's purporting, he's been working feverishly on her defense for months. What do you think? Now, I'm going to be watching for your answers down below, and I hope that you'll read each other's comments and respond to them. Bounce your ideas, your thoughts, your emotions with each other back and forth. Have some conversation. And will you please hit that like and subscribe button? Share Profiling Evil with your contacts, and please consider joining our channel memberships. My favorite, it's the Academy level, where you get information that you can't find anywhere else. Now remember, you can find Profiling Evil on YouTube, Instagram, Facebook, and Twitter. And if you like podcasts, you can find Profiling Evil on your favorite podcast platform. And of course, don't forget to check us out on the World Wide Web at profilingevil.com. Well, thanks again for your support, and we'll see you all soon at the next crime scene.